Check. Yeah, it's good. Hi, everyone. Welcome back from the break. I'm Tom Keck from Syracuse University in the United States. This is my fourth time at the Bergen exchanges, but I had a little bit of a gap, and so it's it's a great pleasure to be back and see everyone. For those of you who are new, you are now figuring out that the Bergen exchanges packs an extraordinary amount of content into every day, an hour, and minute, right? And so we're going to jump right back in to our next panel, which is entitled Courts and Autocratization, right? And so those of you who've been studying autocratization in the PhD course, or those of you who've been researching autocratization for years on your own, it will come as no surprise to many of you that the role of courts in these processes is often quite significant, right? Autocratic leaders quite regularly attack courts or seek to capture courts, seek to either weaken or capture courts as one of their first orders of business. Sometimes they're successful, sometimes they're less successful. In the wake of autocratization, pro-democracy actors also sometimes struggle with how to deal with judicial institutions that have been fully or partially captured by the previous autocratic regime. So there's lots to chew on, plays out different ways in different regions of the world. So here's what we're going to do. I'm going to introduce my distinguished panelists. We do have one change from the program. I'm going to introduce everyone briefly. I've asked them each to make an opening comment of about 5 minutes, and then I might ask a question or two to put them in conversation with each other, and then we'll invite audience questions as well. So we will hear first from Tania Groppi from University of Siena. We'll then hear from Lívia Buzolin from FGV Law in Sao Paulo. And then Luckmore Chivandire from Stellenbosch University. And then Aleksandra Vaisberg from the University of Bergen. So Tania, the floor is yours.
Thank you very much. Thank you very much for organizing this amazing event. It was my first time here, and I'm so happy to be here, so excited. Then courts and autocratization. We talked of democratic backsliding, democratic decay in the previous panels. Well, probably the best term should be a rule of law backsliding, because what happens when illiberal actors keep the power, they usually are elected. We know those processes, then I don't need to add anything in my 30 minutes. Then what happens is that their primary goal is to get rid of rule of law institutions, courts, but not only courts, also fourth branch institutions. And in the context of this rule of law backsliding, the autocratic legalism, I also use the Kim Lane-Seppel definition. Then the autocratic legalism, what happens is that the illiberal actors usually don't suppress constitutional courts, but they try to curb them or to capture them. Then court curbing means blocking or hindering court functions, but what is much more interesting is the court packing. There are several tools. I'm not in order to pack a court. I'm not going to develop here, but it's especially interesting because once a court is captured, the court can become a powerful weapon in the hands of the illiberal actors, in the hands of the ruling the government. There are many experiences that have been explored by scholars, Hungary, Poland, Venezuela, Turkey, Russia, and probably other experiences. And in those experiences, very often, and is what is going on in Venezuela these days with the electoral court, for example, what happens is that the capture court give legitimacy to illiberal acts. And what's more, this is what is going on in Poland, for example, these days. Once a court is captured and the populist regime is defeated in elections, and there is a new democratization, is very difficult for non-populist government to avoid the limits to their acts by the captured courts, unless they pack again. Then this is a dilemma. Against this backdrop, I have 2 points to raise. One is there something new in the populist attacks toward courts? Or those attacks finally are part of this ongoing tension and debate in between legal constitutionalism and popular constitutionalism. I consider that probably we should further investigate the rhetoric of the illiberal forces, the argument they use, and probably as a result of this investigation, a first takeaway, especially for scholars, should be careful when you express your skepticism on courts on constitutional review, because this abusive, finally, use of scholarship by illiberal forces can use these arguments against the courts and the rule of law. The second point would be, but I cannot explore it right now, could be, and this also is quite a classical question these days, how to protect courts in a context of democratic erosion. And here there is a strong focus by scholars on institutional design, and of course I agree. But what I tried to explore in my research is especially how courts can contribute to build a stronger support in the civil society, in their audience, by using communication tools and by fostering what is called constitutional literacy. Then the courts can have a role in order to prevent those changes. And then probably a second takeaway for scholars and for courts would be, as Marty de Visser pointed out, that prevention is better than the cure. Then probably we should, and courts, scholars should try to prevent autocratization also by fostering the constitutional literacy and using the new communication tools. And this issue, I think, deserves further research by scholars, not only by lawyers. I try to do it as a lawyer, but probably also communication experts and other social scientists. Thank you.
So thank you, Tania and Tom, and my Sasha and Luckmore that we'll be hearing. Thank you, City, and everybody for the invitation and to be here again. It's my 3rd time, I think. And I will be go straight to the point that I want to make, because I will be talking about the Supreme Court in Brazil and how the court acts on judicial review. And in 2 authoritarian periods that we had the military regime from the 60s to the 80s, and then we have the Bolsonaro government from 2019 to 2022. So they are different regimes, but they all have kind of non-democratic features. So First, Luciana, Fabiana, and I, we did a research on the cases of judicial review in the last 10 years of the military period, and then in the first 2 years of the Bolsonaro government. And what we found out is that the same superior court can act differently in a non-democratic basis. So for the military regime, we noticed that first it was the Attorney General acted as a gatekeeper towards the actions that the cases that could get to be trial by the Supreme Court. But with the few cases that actually were trial by the Supreme Court, they were related to labor rights for the public officials. So it was kind of more of a governance instance for the military and what was going on. And it was also kind of in the interest of the justice themselves, because the judges, they are like public officials in Brazil, so it was kind of deciding labor rights, pensions and stuff like that. So that's how the court acted in this first period. And in the second period, during Bolsonaro's government, we found out that it acted as a locus of resistance. So first, opposition to the government could access the courts to claim numerous ways of actions. But in the second, after the pandemics in 2020, another research from Oscar Rubens and Laura, they found out that actually the courts there was a shift, and they started to control more of Bolsonaro's acts after the pandemics, and because they were in the beginning more of a conciliatory position, trying to see what Bolsonaro would do once in power, but then they start to take measures and control the acts. And so you can see the same Supreme Court acting differently in two periods. And in the more recent period, they were more of a resistance side. So that's not because judges finally realized, oh, we should not be so in favor of autocratic leaders, but also in between this period, we have a new constitution, we had a new set of cases that could be presented before the court. And we also had the expansion of the people who could access the court through judicial review in Brazil. So that helped a lot, because in the first period, we only had, I think, only the Attorney General could access the court. So once you expand like to political parties, to kind of some organizations with federal representation, to the Senate, to the House of Representatives, so you have a broader scope of actors that could access the court. And also, so that helps for the courts to not be captured during Bolsonaro's government, but also to act as a resistance actor as well. And to give like a concrete example, my work is on LGBTQ rights and gender. So in the case of LGBTQ rights, it was really curious because most of the rights that we have in Brazil came from the Supreme Court, right? So they are kind of proud of being the court that grants all those rights. And Bolsonaro, he has been homophobic and misogynist since he was a lawmaker. He was a lawmaker for 20 years before getting into government. So it was kind of expected that he would go against LGBTQ rights, right? So what the court did, they actually ruled like two kind of cases that was really a message against Bolsonaro. They criminalized homophobia and transphobia. And in the second hand, they ruled 8 cases about sex education on school. So because Bolsonaro was manipulating gender ideology a lot, and a lot of states and municipal laws were passed saying that people could not talk about gender and sexuality at schools. So the Supreme Court used this space and said, no, they can't talk. We are granting freedom of speech of the teachers. And these cases, they were not filed during Bolsonaro's government. That's interesting. They were filed before Bolsonaro was in power, but the justice, they used their agenda power to rule those cases during his government. So that's really interesting, the timing that they used over time. So just to give an overview of how there's also another aspect, because Bolsonaro was personally targeting the justice, right? He was calling Justice Roberto Barroso a thug. He was going to the press. During the pandemic, he was saying that the Supreme Court should be shut down because they were against the government's measures to contain the pandemics, which were actually no measures at all. So just to give an overview, it's a case also in the last period of almost personal confrontation, and led to, in the case of LGBTQ rights, to favor, we have more rights than we had before his government. So it was also an interesting result of what the courts could act. But I will stop with here. Thank you.
Thank you so much. Thank you, Siri, for the invitation, and thank you, everyone, for attending this session. Okay, so I decided to send my presentation on Zimbabwe, judicial capture in the case of Zimbabwe. Those who know Zimbabwe, you know that Zimbabwe was once colonized by Britain, and when we got independence in 1980, the judiciary was a bit fair, it was a bit independent, but along the way, a lot of things happened which resulted in a situation where the judiciary is believed to be captured. So I would like to borrow from the theory of capture, which basically says capture occurs when there is disproportionate power between the regulator and the regulated entity or entities. So in this case, we have got the regulator, which is the judiciary, which is supposed to regulate the powers of the executive. But when the executive has more powers now than the regulator, it becomes a problem. And there are some drivers of this disproportionate power or of judicial capture. Number one being capture by appointment. So appointment of judges is very critical. Who appoints, who has got the power to appoint. So in the case of Zimbabwe, we had a new constitution in 2013, and the constitution had some safeguards on the appointment of judges. There was supposed to be a public interview process where everyone could see the judges being interviewed. And that was a good move. But in 2017, there was a constitutional amendment that said, no, judges, the Chief Justice, the Deputy Chief Justice, and the Judge President of the High Court are not supposed to undergo through this interview process. They're just nominated and appointed by the President. So automatically we see that there's a problem when the executive has got the power to appoint. And in 2020, another constitutional amendment happened where the president again was given powers to promote judges of superior courts. That's from High Court to Supreme Court. The president can now promote without going through the interview process. Hey, my time is ticking away. Okay, the second driver is compensation. The person who compensates or who is responsible for compensation, he has got the power to influence decisions. In the case of judges, in Zimbabwe last year we had the elections, and there is an allegation that judges were given $400,000 loans 3 months before elections. And we know that Zimbabwean elections always go to court. After elections, there are some petitions. Judges were given $400,000 loans, and we know what happened later. Then another power is the removal. Who removes the judges? So we've got the tribunal system in Zimbabwe where a tribunal is set up, but who appoints judges in that tribunal? So if there are allegations that a judge has performed a misconduct, the president sets a 3-panel tribunal, and he says it on, alone. He does not consult anyone. That's a big a problem as well. Then there are some orders from the Chief Justice that have been happening over the past years, where the Chief Justice, I think in 2019, there was an order that all judgments were supposed to go through a superior. Before a judge delivers a judgment, he or she has to show his or her superior that judgment before delivering it to the interested parties. But of course, there was a public outcry, and that was withdrawn. But what I am saying here is there is need for us to balance the power between the appointer, the regulator and the regulated entities. So we need to restrict or to reduce the powers of the executive. And how can we do it? There are several ways. I checked in the Zimbabwean constitution. I just did a quick Google search. A search, and I realized that the name president is written more than 500 times. The president is an imperial president with so many powers. So there's need to check those powers, reduce the powers. The president appoints members of the Judicial Services Commission. The president nominates people who are appointed as judges. So the president can nominate to say, I want 1, 2, 3 people to be part of the interviews who are going to, to be interviewed for the High Court judges. And by so doing, the president, actually after the interview, he has the responsibility of choosing who is going to be appointed. He has to consult the Judicial Service Commission, but the consultation is consultation. He is not obliged to follow what the recommendations of the JSC have said. I think my time has ended. Thank you.
Yeah, so thank you for the invitation. It's a great honor to be a participant of such a distinguished panel. And the focus of my work so far has been on legal mobilization in Russia. So I'm going to try to cover the topic of courts and autocracy in Russia and perhaps touch on some other post-Soviet countries if time permits. So I feel a bit like an odd person here, because in the context of autocratization, people often talk about democratic backsliding, but in the Russian case, arguably there has been nothing to backslide from. And moreover, in this panel, we are supposed to talk, at least according to the description, about the superior courts. And in this sense, perhaps, for instance, the Russian Constitutional Court is not very interesting in the sense that, well, there are no surprises here because it's like loyal to the regime and kind of tame. However, just to provide a bit of a historical perspective, I would note that it has not always been the case. And in 1993, when there was a constitutional crisis in Russia, a conflict between the Russian President Boris Yeltsin and the parliament, the Supreme Soviet, and the military was on the streets of Moscow shelling the parliament building. The Constitutional Court actually opposed the president and didn't side with him, despite the threat of being perhaps shelled as well. But a lot has changed in these 30 years. And there were some dissident judges in the Russian Constitutional Court who expressed various special opinions. But some of them were forced to leave, some left because of their age, and the last one left on his own initiative. His name is Konstantin Aranovsky, and he left in 2022. Well, and there it's perhaps not a coincidence, and this has been considered a form of protest on his side because he was not willing to take part in the decision-making concerning the Russian so-called new or occupied regions. But I would also note that despite this perhaps insignificant role of the Russian Constitutional Court, the Russian human rights defenders still try to use it for strategic litigation, although without much hope, but at least with, as they said, with an idea that it might perhaps interpret some of the newest repressive Russian legislation and perhaps limit its sphere of implementation and application. But I also want to mention that apart from the superior courts, I believe that in the Russian case, the lower level courts should also be part of the discussion because, well, for one, these are the courts that persecute the activists and ordinary people for like various crimes, such as, substituting the price tags in the store with like the information about like Russia, about the war between Russia and Ukraine. And the lower level Russian courts also become the arenas for contestation where the human rights defenders try to defend those people persecuted on political charges. But even apart from the explicitly political cases, the Russian courts are might be interesting because, for one, the acquittal rates are extremely low, and the researchers, for instance, talk about bureaucratization of the courts, and the judges have to make decisions very quickly and in a very mechanical manner. But they also, these studies also mention the feminization of the Russian courts, which also touches upon another topic of this conference, which is gender and autocratization. And so, generally, I would say that in authoritarian contexts, it might be important to study courts at different levels, using different approaches, including perhaps the ethnographic methods and the biographical and demographic studies. And finally, another point that I wanted to mention is that where do you go if you do not have an option to rely on your national legal system? Well, perhaps you might want to appeal at the supranational courts. And this has been important for Russians and for Russian human rights defenders. The European Court of Human Rights has been an important mechanism. But it has not been available since 2022 when Russia was expelled from the Council of Europe. But it opens sort of another avenue for research about the substitutes that Russian human rights defenders have found for the European Court of Human Rights, which includes the United Nations mechanisms and the Organization for Security and Cooperation in Europe, including the interesting, remarkably titled Moscow mechanism. And generally, I would end saying that Russia is actually not alone in not having access to supranational human rights courts. And many countries in the post-Soviet region, including Belarus and Central Asian states, also don't have this option, which is somewhat unfortunate if you think about it, because these countries actually are the autocratic regimes with serious issues related to human rights and rule of law, but they do not have this option to, the citizens of these countries do not have this option to appeal to the supranational mechanisms and potentially build the basis for future legal reforms, or at least to get the compensation for human rights abuses. Thank you.
Thank you so much to the panelists. So I'm going to make a comment or two reflecting on the presentations, and then pose a question or two, and then give each of the panelists a chance to weigh in one more time, and then invite audience up to the microphone for further questions. So just a couple reflections. So courts are often described as guardrail institutions. Constitutional court judges often tout guarding and preserving democracy as one of their primary functions. Constitutional designers often have explicit conversations about building an independent set of courts to help preserve democracy. The founding of the European Court of Human Rights, for sure, that idea plays a big role, but also with lots of national apex courts. But my sense is that the actual empirical record of courts effectively guarding democracy in the face of erosion or backsliding or decay is mixed at best, right? I mean, I think is maybe generous. There are some positive cases, and maybe Brazil is an exceptional case. in some ways. So I want us to sort of reflect a little bit more about what, Bolsonaro only had one term in office, right? A second term obviously would have led to a different kind of court. But also, are there some key features of the institutional design that just worked well to prevent him from fully capturing the court, or is it some more particular features about the judges themselves who, some of them proved particularly willing to challenge Bolsonaro on issues of gender and sexuality, but also on issues of free speech. We'll talk a little bit more about that after lunch. And election administration, for sure, right? So like, what is it that, like, are there, I'm sure there's some other positive stories besides Brazil, but can we reflect some more about why the Brazilian case is different? But elsewhere in the world, right, there's lots of negative cases, right? And whether it's because the processes of autocratization, proceed so far that no possible court could have stood in the way of the authoritarian leader, or whether it's because, a history of weak institutions and some poor design features, leads the judges to be dependent on bribes for their livelihood, and then they're not in a very good position to resist demands from the executive and the like. So there's lots of negative stories, and even in nations which we think would probably have much more resilient democratic institutions, right? So even in countries like Hungary and Poland and the United States, right, the record, the sort of capacity of the court to withstand, let me say, the will and the capacity of courts to withstand profound pressures for autocratization, right, have often been quite limited. And so I'm just going to ask each of the panelists to reflect again based on the cases that you know best, the courts that you know best, but also sort of reflecting on what's going on elsewhere in the world a little bit. What would you say? So I guess it's going to be a two-part question. The key features of institutional design that you think have played an important role or should play an important role, but also because in so many of these processes, we're not starting from scratch, right? We don't have a chance to like draw up the apex court of our dreams, right? And so, in the context of imperfect institutions, like, to what extent do you think democracy advocates can still make productive use of judicial institutions in an effort to defend democracy? And are there thoughts or ideas that you have for sort of fostering and improving those efforts? And I guess I'll ask y'all to weigh in the same order that we went before. So Tania, you're first.
Yeah, thank you. Yes, this is the real question, which are the factors that can explain the resistance of the courts, and is really difficult. I did quite a lot of comparative research on this topic, and I still don't have an answer. Probably institutional design can be part of the explanation, especially the appointment process. For example, the fragmentation of the appointment process can be part of the answer. But we have a counter example, for example, Czech Republic. In Czech Republic, if you consider the institutional design for appointments, it's so bad, really bad, because all the 15 judges are appointed for a 10-year term, all at the same time, all together, by the President of the Republic, with the consent of the second chamber, by simple majority. Then this is really awful system, giving the political majority the possibility to fully control the court. But it never happened, notwithstanding this bad institutional design never happened. And finally, all the presidents appointed quite independent judges. And the main explanation is based on political fragmentation of the political context in Czech Republic. But I could also add, finally, an important legal tradition, because finally Czech Republic before the communist regime in the 20s was the home of the first constitutional court, even before Austria, worldwide Kelsenian, under the Kelsenian influence. Then I think it is much more a matter of the global environment than trust in court, the civic context. There are courts, Israel, for example, let's think about Israel, courts that took a very bold position, these unconstitutional constitutional amendments, declaration in a context such Israel without an entrenched constitution, for example, just basic laws. And the 1st January this year, the court struck down a basic law that was considered inconsistent with supreme principles, then which is the background of that decision, and probably is the general environment, I think. Then, for example, the civil society resistance that in Israel was so strong against the judicial overall. And probably there are also other examples. Brazil was one of those examples of trust. Probably I just put this for next intervention, but probably it was one example of trust in courts by the society. For this reason, I consider that it's so important for courts to try to foster the public trust, the constitutional literacy, that you just try to explain to the people something more about what is a constitutional democracy based on rule of law, which is the role of the courts. This is job for the academia, this is job for the civil society, but it is also, in my view, part of the job of the courts. Extrajudicial activities of the courts are becoming more and more important. Then, yeah, I think it's this environment we should focus on.
So, kind of in Brazil, the resistance was not only led by the Supreme Court, but it was also, we had a civil society organization, the feminist movement, the queer movement. So, but I think what helped to have a united front that I'm still looking for to investigate if it was coordinated or not, was that Bolsonaro was able to attack so many people that it was kind of difficult to not resist him. So he was targeting the justice personally. He was targeting the Congress. He was saying civil society organizations were a cancer to be extinct from the country. So it was kind of hard not to resist what he was doing, right? So, but the Supreme Court has been gaining power over the years. I think now kind of everybody knows at least the name of one justice from the Supreme Court. And it became, of course, with the Constitution from '88, but also they broadcast their sessions, the rulings, so it's on TV, you can watch, and they trial larger cases of corruption after 2005, if I'm not mistaken. I'm looking to Raquel and Luciana because they are the experts, but I mean, and then kind of Joaquim Barbosa, who was a justice at the time, he became like this hero. You can go to the streets on Carnival and people were dressed like him. That's how popular he was. So, and that was getting bigger over the years. And then Bolsonaro went straight attacking these people. I'm not saying now it's kind of like it's in most autocratic, post-autocratic regimes, this polarization that now people kind of personally hate these justices. But I mean, the way they handled, I think the topics they chose to rule, it was really vital for the resistance because it was kind of combined with other actors were doing as well, like the civil society, the feminist movement, and I think overall it was successful because so many people were angry and feeling offended and feeling scared as well. So it was hard to it was not easy, but it was a successful way of resisting the thing. And we don't have like the most easy Supreme Court to access, because you need a lawyer. You need there's a lot of compared to Latin America, you have a boxes to check. But I mean, in the end, they using those cases that were already there and making a statement was really helpful. So yes.
Thank you. Dwelling on the example of Zimbabwe that I gave, the issue of institutions is very important. Like I mentioned, the issue of who appoints, but one important aspect that is often neglected is the issue of who can amend the constitution and when can a constitution be amended. A constitution is not supposed to be a fixed document. It can be amended, but there are some safeguards. You know, there's this issue of, I'm not a lawyer, but and I think there are lawyers in here. The basic structure of a constitution must not be easy to amend. There are certain rules that must be followed. Like, for example, if something affects the independence of the judiciary in the constitution, it must not just be amended by 200 people or maybe elected parliamentarians. It is something that should go maybe through a referendum. The public must be engaged and they decide whether they want or not. An example, in Zimbabwe, we had 2 constitutional amendments that affected judicial independence, but that was done without consulting the public. So I'm saying, at least if you are going to amend the constitution, why don't you consult the people? It must not be just easy to amend the constitution. An example is in Kenya. For Kenyans to amend their constitution, as long as it is something that affects the judicial independence, there must be a constitutional referendum, and the majority must vote for that particular amendment. Then I also want to say the fact that courts may be captured must not act as an inhibition or must not prevent people to go to courts. Actually, when people go to courts, it is there for the world to see. Right now, we are talking about Zimbabwe. The international community is hearing about it. So when people talk about it, you know, there was a person who spent almost 600 days in remand prison, Job Scala, a politician in Zimbabwe, for a case that he was acquitted of after 600 days in prison. That's almost 2 years. So the international community has been watching, and it brings to the brings to the forefront of what is happening in Zimbabwe. And you know, this international pressure actually works. The reason why in Zimbabwe there was a unity government in 2008 was because the international community knew about it. So what I'm saying is, it is very important, even if the courts are captured, go there as human rights defenders to expose it to the public. Even if you lose, if you have got the resources, I would advise maybe let's go. The judgments are there for people to see. It is the public that has got the final say. Thank you very much.
Yeah, so the first thing that I guess I wanted to say is that I guess the Russian experience, like returning back to 1993, shows that this sort of oppositional stance of the Constitutional Court can actually backfire, because in these conflicts, the president and his allies actually kind of won, and they were the ones who shaped the Russian constitution that was adopted later that year, and they generally the constitution granted a lot of powers to the executive and specifically to the president, but it also limited the capacities of the Constitutional Court, and for instance, it limited its capacities for the judicial review, and generally the court was dismissed, and the chairman of the court lost his position. He later returned and became much more loyal to the current president, but still overall it was perhaps one of the critical junctures for the Russian institutional design in general, and particularly for the Russian Constitutional Court, which no longer could take this sort of a stance. On the other hand, if I may recall a more sort of positive example also from the post-Soviet region, what comes to my mind is the case of Ukraine and the Orange Revolution of 2004, when, if I'm not mistaken, the Superior Court confirmed that the results of presidential elections were rigged. But it was, of course, sort of an outcome of a long struggle, which involved, the united opposition and the mass nonviolent protest. And I don't want to go deep into that. I'm not an expert on Ukrainian politics, but the differences in the institutional design and political regimes of Russia and Ukraine have been perhaps widely discussed, especially in the last 2 years. So I guess here also this overall context really matters, and in Ukraine the executive does not have such wide powers, and perhaps this was at least one of the factors that allowed the court to preserve its autonomy compared to the Russian Constitutional Court. So I guess that would be it from me.
Great. Thank you so much. It's time for audience questions, so please join the queue. Namita, whenever you're ready.
Yeah, thank you. Thank you for this great panel. I wanted to pick up on what you said, Tom. Hello? Can you hear me? I wanted to pick up on what you said, Tom, about institutional design and press the panel to think about institutional design not just of the courts, but institutional design of all the organs of government relative to the courts, because I think that is actually perhaps equally crucial as the institutional design of the courts itself. To give you an example from India, we find that within the parliamentary system of government, the time that the courts have been the most active is when there have been coalition governments. In other words, the institutional design of a parliamentary form of government, in the case of an absolute majority, renders the legislature and the executive way too powerful vis-a-vis the courts. But when it is not within that system as powerful because it is not a majoritarian government, then the courts become more powerful. So that's the first point. The second is to sort of think about institutional history and the political history of the state as well as we think about the courts. Because for at least for countries that have emerged from British colonial rule, and this is part of my own work as well, is that we see that because courts were the only check on authoritarian rule, they typically tend to be more active in terms of holding governments to account. And the third thing I wanted to say is just about the counterfactual. So I personally feel that even though courts in India have often disappointed us, the question for us to consider is whether we are putting too much pressure on the courts, and because are we expecting too much from them more than they can deliver? What is the counterfactual? Because even in the limited instances, in 10 instances, if the court doesn't intervene, it disappoints us because we expect it to intervene every time. But the one instance that it does intervene, when it is significant, like in the electoral bonds case, it can actually have some kind of impact on whether a country becomes more authoritarian or less, and how do we measure that vis-a-vis the other instances when it doesn't? Thank you.
Hi, Michał Stambulski, Erasmus University, Rotterdam. one of the difference between autocratic power and autocratic court is that autocratic courts are obliged to justify their decision. And in doing that, they use some kind of legal concept. So I'm wondering whether could we identify some kind of concepts that those autocratic courts use when justifying autocratic regime, and what kind of concept do they use when they oppose autocratization. And my suspicion would be probably that those autocratic courts tend to use more of a legal pluralism language. Comes to my mind the Valery Zorkin, the chief of the Russian Constitutional Court, famously used living constitutionalism as a justification of the autocratization of the Putin regime. A Hungarian Constitutional Court uses the constitutional identity. So there is some kind of language of legal pluralism when those courts are justifying their some kind of autocratization, which poses important challenge for us who have some kind of pluralist commitments and democratic commitments as well. But when the court, when they oppose, they probably use more monist language connected with the rule of law or some kind of universal standards. So I'm curious, from your jurisdiction and in your cases, do you see any pattern emerging or some kind of legal concepts that are used to justify autocratization and to oppose it? Thank you.
Thank you. My question, I will address it to Luckmore. You don't have to look at Kenya. Just check South Africa. The amendment of the Constitution requires two-thirds majority. That shows you how important it is. But with respect to Zimbabwe, if you read the case law in Zimbabwe, especially on judicial review, you can see that the courts are somewhat, the subordination of the courts to the executive. It's extreme, what is called vulgar positivism. You have what you call executive-minded judiciary. And as a way to protest against the draconian powers given to the president, don't you think the resignation of the judges to protest against the powers given to the president to abuse the independence of the judiciary, because it has ultimately resulted to the erosion of the independence of the judiciary in Zimbabwe, can be a solution or an available remedy to protest against the executive abusing the independence of the judiciary?
Hi, I have two questions. One to Lívia and the other to Tania. Lívia, I wonder, in your comparison of the two courts reacting or being resilient to autocratization regimes, the military and the Bolsonaros, have you been able to compare or to map out the origins or trajectory of the judges? I mean, the legal education of the judges, the origins. So it might, because besides the context, in the military there was a threatening maybe of against their personal, integrity, physical integrity. So I wonder whether there is any background that you can relate to their decisions. And to Tania, I like your idea of constitutional literacy to prevent autocratization, but I wonder whether this literacy, or courts literacy, constitutional literacy, is used by courts to prevent themselves to be removed. If you know any successful case of constitutional literacy that you can explain, or you can comment to us. Thank you.
So hi, my name is Ana. I'm from Guatemala, and one of those cases of captured courts. And my question was for Tania, and because so you said that in your comparative work you found the constitutional literacy plus the communication tools very important to keep courts protected. But I was wondering what are the conditions for that to happen, because at least the case I know, even those spaces that could be used for the protection of courts are being manipulated in the autocratization project. The constitutional literacy is being all interpreted, like constitutions are being interpreted in other kinds of ways that are not democratic, and the communication tools is being also attacked by the prosecutors, and the prosecutor's office unleashing all the weapons of criminal law just to dismantle all kind of opposition. So I was wondering if those tools that you were talking about, is it because there is still places where autocratization hasn't been present? Thank you.
Thank you. This was such a fantastic panel. I'll keep it short. Just one question, mindful of the time. This question cuts across several insights that you have put out during your presentations. And I wonder whether, for instance, the fact that institutional design, the communication strategies, the fact that the political leader gained plenty of enemies due to her attacks, to what extent do those analytical insights hold for lower tier courts? Lower tier courts who are at the forefront of the day-to-day, I would say, political economy disputes, land tenure aspects, and so on in your respective countries. Thank you.
Thank you, everyone. Great questions. We're obviously low on time, but I'm going to invite each panelist to respond to one thing, like 1 minute each. Don't try to respond to everything, and obviously everybody come find us during lunch and have further conversation. Tania.
Yes, I fully agree with the fact that institutional design in general is important, then not only institutional design of the court, but the institutional design in general, then this fragmentation between parliament, government, and courts, for example, and also decentralization and so on. And I haven't found any evidence that the capture courts use legal pluralism arguments. Most often they rely on abusive comparativism, for example. Constitutional identity is an example. And to conclude, cases, of course, that are using the communication tools at the moment to improve constitutional literacy, there are many. I would like to mention Colombia firstly. And I published also in English an article on this issue, and the article is on the table if you would like to have a look to the cases. Thank you very much.
Thank you. Lívia.
Very quickly, no, I haven't looked at the background, but Fabiana Lucy Oliveira, which is our co-author, she did, because she has been working with this agenda, so I can recommend you later. And just for the legal arguments, in the case of the LGBTQ plus rights in Brazil, what I have been noticed is that when the justice wants to avoid or he doesn't want to look like he's against LGBTQ rights, he goes for the formal aspect. So he says, oh, the court should not be ruling about this. It should be the Congress or the executive. And so it's a form of avoiding the topic. And actually, not all the justices were in favor in these cases during Bolsonaro. There's one that were against, and that's the argument he used. This sex education should be a matter of the legislative, not the Supreme Court. And he retired and then declared himself in favor of Bolsonaro because so that's another feature, but usually it's what I have been seeing. What they do is to avoid by going to the formal thing.
I will respond to Stelo. Yeah, the 2/3 majority, even in Zimbabwe, there's a 2/3 majority rule to amend the constitution, but we are assuming that we have got a perfect situation. Zimbabwe is a special case. We have a situation where the president goes to the opposition, removes the opposition leader, installs a leader of his choice to be the opposition leader. So in that case, even if there's 2/3 majority rule, who is going to win? It is the president's decision. Then on the issue of judges, where we should allow judges maybe to protest against threats to their independence, that again assumes that there is a perfect situation. But in the case where the president is appointing 90% of the judges, it becomes a bit of a problem. But that's a good point. We can discuss outside. Thank you.
45 seconds. Yeah, so I will try to touch upon the question on legal pluralism, but I would say that I'm not, and I haven't like closely studied the decisions of the Russian Constitutional Court, but I would say that like from the research that I know, at least part of the explanation might be that the court might at least partially follow the agenda set by the political regime. For instance, there has been a period in Russian history, like in the Russian contemporary history, from when for a short period of time the president was not Vladimir Putin but Dmitry Medvedev, and so Russia kind of was striving for modernization, and according to the literature, this sort of incentivized the courts and the legal system to follow the decisions by the European Court of Human Rights. But gradually, perhaps this agenda, this discourse of modernization shifted towards the focus on sovereignty, for instance, and I would suspect that we might find the appeals to sovereignty, which is sort of a maybe a legitimate notion of its own, in the decisions of the Russian courts. Thank you.
Thanks, everyone. Please join me in thanking our panelists one more time.